These are NCA's guides.
Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian administrative law exams.
I have taken and passed the Canadian professional responsibility examination.
I have written and passed the Canadian criminal law examinations.
I have written and passed the Canadian constitutional law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present and will help candidates overcome these difficulties and obstacles in understanding the course materials and the exam format.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a good track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.
Hi, Abaka, it's good to see you. Thank you for turning your camera. Again, I'll reiterate, my preference is that your cameras are turned on. I'll diverge from the instruction of the introductory video and say that I absolutely don't mind your mics being unmuted if your background is quiet, so that you can ask me your questions and, add in your contributions as they show up in your head before you think yourself out of it, right? If that's fine. So I think that, the assumption or expectation with this course, hi Olabisi, is that a number of people who come on introductory classes, I haven't started to read, study, or even if you've started, you haven't gone as extensive into the syllabus. So the structure that we've chosen to adopt is to run through the syllabus as quickly as we can, give an overview of each of the 20 chapters. And then I also like to point you to, sports that I think you should pay attention to and ensure that you have a good grasp of, whilst you're studying. Again, if I'm speaking too fast or you need me to say something again, just indicate to turn on your mic and interrupt me, and then I'll go over it. So generally with the NCA exams, it's very, very crucial that you study with the syllabus. Very important that you study with the syllabus, because constitutional law, the syllabus isn't as instructive as, for instance, criminal law or administrative law. It pretty much just gives you the topics, and then maybe one-liners or a few cases, 1 or 2 cases. But you need to pay attention to those cases and to those topics, I beg your pardon, and ensure that you zoom in on them and you don't go out of context or out of the scope of the syllabus. So I imagine you all are joining on internet connection, and you should be able to pull up a web page if you don't already have your constitutional law syllabus printed out. So if you don't have it printed out, please, if you can, pull up a web page on the NCA website, and you'd find the syllabus for constitutional law on there, and then we can start reviewing, topic after topic. So the first topic is sources and nature of the Constitution. By way of a general overview of, Canadian constitutional law, the NCA course. What it is, the long and short, length and breadth of it is that we are reviewing the Constitution of Canada. We're reviewing constitutionality, its existence and its operation. the existence and the operation of constitutionalism in Canada. And I mean, I also know from personal experience and from interacting with a number of candidates that when you open up your study materials, the first chapter of constitutional law typically will make you close your books and just run away on first attempt, because it just looks, because it has a bit of history going on there. It just looks like, what exactly are they talking about? But so I tend to spend a bit more time on that first chapter in my introductory classes, but just have at the back of your mind that throughout the course, for everything you read, for every new thing you get exposed to, what question you want to ask yourself is, how does this amplify or indicate constitutionalism in Canada? Again, I'm using constitutionalism because I take for granted and assume that everybody's familiar with that term, and it just pretty much means a system of government where a single document is recognized as the constitution, the ground norm, the principal law, and a legal principle that dictates that every law and every action of government is consistent with that single document called the Constitution. Are we good thus far? That is constitutionalism, where legislations and acts of government or actions of government officials are mandated to be consistent with the constitution of that country. So as you go along, with your study, running through the syllabus, preparing for the exams, always ask yourself, how does this show me the effect of constitutionalism in Canada? That is all that this course is about. What is the Constitution of Canada, and how does it impact the style of governance or the system of governance in Canada? So having said that, we go to the first chapter, sources and nature of the Constitution. Again, as it sounds, so I typically say to my candidates or to my clients, constitutional law is the course to take on face value. Take it the way it sounds. Don't be tempted to assume or to second guess yourself on the basis that it should be a bit more complex. It really isn't any complex. It's just as it sounds, right? And I think pretty much with a lot of Canadian course content, there's no Latin maxim, there's no complex word that sounds completely different from what the actual import is. If you turn on your simple understanding of English language skill, you would walk through it a bit more easily. So just like the first chapter sounds, sources and nature of Constitution. What speaks or what informs the Constitution of Canada? From where do we derive the Constitution of Canada? And what is the nature? How is it presented? What form does the Constitution of Canada take? Now that opens up the conversation into the sources. No, I'll start with the nature. Let's speak to the nature first, and then we go into the sources. So the nature of Canada, off the top of your head, anybody asks you, is that two things stand up for the Constitution of Canada. It is written, and it is not contained in one single document, right? And, if you start to review your course materials, you'd see that, of course, it's probably general knowledge that Canada was colonized by the UK. It used to be known as the British North America colonies, right? So it was an English colony. And even till now, after independence, we still see the influence, a very heavy influence, UK influence in Canada, right? Till date, the Queen of England is still the Queen of Canada. So you'd see that, influence in the constitutionalism in Canada, in that, whilst the Constitution of Canada is written, unlike the UK Constitution that is, almost completely unwritten. The Constitution of Canada is written, but it is not contained in one single document, as you'd find with a lot of regular and typical democracies or federal countries. Does that make sense? Does that make sense? It is not contained in one, there's not one single body of document that is referred to as the Constitution of Canada. It's, off the top of my head, about 30 different documents that have been pronounced. Relax, Amaka, we won't get to understudy all 30. It's just two of them that are very important for the purpose of the NCA course. But in all, there are, about 30 of those documents that have been pronounced and, recognized to be the Constitution of Canada. Very important that you know that, and very important that you know that it is written, right? And there's a lot of background history conversation to have, some of which I might get into to say that, again, because the concern for the course, the two principal documents that concern this course are the Constitution Act 1867 and the Constitution Act 1982. Very important that you get those clearly, and then I'll speak a bit into what roles, what position each of those documents take. But for the purpose of the NCA exams, those are the documents you need to bother your head about: the Constitution Act 1982 and the Constitution Act 1867. So, as a bit of context or history background, Canada used to be a colony of the UK. The Constitution Act 1867 was drafted, put together by the Privy Council in the UK for Canada. Now, it was a Canadian document, the Constitution of Canada, but it wasn't drafted by Canada or in Canada or by Canadian parliamentarians. It was drafted in the UK. Important features of that document that are relevant for the purpose of our conversation is that whilst it presents to be the Constitution of Canada, it was completely silent about, amendment procedures. Does that make sense? It was completely silent about amendment procedures, and the effect of that, why that becomes an important conversation to have, is that Constitution, that document, could not be amended in Canada or by Canadian parliamentarians. There was the need to, revert to the UK to ask if there was any need for an amendment to be effected. The UK had to do it. So Canada was still very tethered to the UK. You couldn't particularly call that a sovereign or independent state. Does that make sense? So that constitution didn't, come with independence or sovereignty. Do you understand? Canada was still very tethered to the UK. It didn't have an amendment procedure, and it also didn't provide for civil liberties. When I say civil liberties, I mean human rights. Does that make sense? Human rights, the right to life, the right to that, and all of that. If you ask me, those are the very important features. Of course, when you go to study, you'd find, expansive material on that. Please read, please be familiar with them. But for the purpose of a targeted conversation, those two are very crucial characteristic of the Constitution Act 1867. Now, those kind of sound like negatives, but the positive that the 1867 Constitutional Act had, or still has, is that it pretty much provided for federalism in Canada. Now, you read through that document, you don't find anywhere where it expressly declares Canada shall be a federal state. But, it had Section 91 and Section 92 that divided powers between the federal government and provincial governments, and listed out heads of powers, that are competent to each of these levels of government. Does that make sense? Now, we remember that federalism or a federal state, really, that is what it is: a system of government where powers are divided between two levels. Now, not branches of government. Branches, you would be referring to judiciary, legislature, and executive. But for federalism, we're talking levels of government, a federal or a state, local, provincial, whatever you choose to call it. In Canada, it's called provinces, called provincial. So it divides powers between, two levels of government, whilst ensuring some form of autonomy, I beg your pardon. Right. So whilst the Constitution Act 1867 doesn't expressly declare Canada to be a federal state, the effect of Sections 91 and 92, pretty much bound Canada into operating a federalism. Are we clear? So you think of the 1867 Constitution, first thing that should come to your mind is federalism. You hear Constitution Act 1867, ding, ding, federalism. You hear federalism or federal grounds, ding, ding, Constitution Act 1867. Are we good? Right? Then we cross over to the Constitution Act 1982. Now, of course, between 1867 and 1982, independence talks had advanced between Canada and the UK. Canada had operated the Constitution Act 1867, and I've been able to, highlight issues, areas that needed, to be improved on in the event that, they eventually got the autonomy and independence, to come up with a document that would be, the Constitution of Canada. Again, does that make sense to you? So with the 1982 Constitution, just like I had highlighted with the 1867 Constitution, the ills of the 1867 Constitution were kind of like the focus, correcting those ills were kind of like the focus of the 1982 Constitution. So the 1982 Constitution Act is passed. This time it is drafted by Canada, by Canadian Parliament in Canada. And of course, it provides for and introduces amendment procedures, as well as civil liberties in the form of the Charter of Rights and Freedoms. Are we good? So you hear that, take notes, where it said, at the start of this conversation, that the nature of the Constitution of Canada is that it is not contained in one single document. So that automatically says to you that the 1982 Constitution Act coming into force did not repeal, does that make sense, the 1867 Constitution. They both, till date, operate at a constitutional level. In fact, in my opinion, two of the most important constitutional documents in Canada. So it didn't repeal the 1867 document, the 1867 Constitution Act. Remember, I said once you hear the 1867 Constitution Act, what should ding in your head, what should come to mind almost immediately? Federalism. So the coming into operation, the passing and coming into operation of the 1982 Constitution Act did not by any way rob Canada or disrobe Canada from still being a federal state. So Canada is still a federal state. There's still division of powers pursuant to 91 and 92 of the 1867 Constitution Act. But 1982 Constitution Act now introduces amending procedures such that Canada can now independently, sovereignly, without having to consult or confer with the UK, amend its constitution, whatever expansive definition is given to that term, right? Which, by import also includes the 1867 Constitution Act. Does that make sense? Right? And then the Charter of Rights and Freedoms, which provides for civil liberties in Canada. If you get that, I'd feel like at least 30% of my work is done. so you see, very important, if you get this concept, it will guide you, it will give you very priceless context and perception rather, throughout the syllabus, as throughout your study. So you hear the 1867 Constitution, you think of sections 91 and 92, divides powers between the federal government. These are the powers you can exercise, federal government. This far, no further. And then it provides for 92, these are the things you can exercise powers over. You can let provincial government, this far, no further. The import of that is that it creates inevitably a federal state. It creates federalism, and then you think of the Constitution of 1982, you think of amending procedures. Now Canada has the independence and the autonomy to amend its own constitution, right? To amend its own pretty much Constantine documents, right? And then you think of the Charter of Rights and Freedom. Now Canada has provided for fundamental, rights, fundamental human rights for Canadians. Does that make sense to you? Any questions, comments? We proceed? Okay, so that pretty much takes care of the nature. And there's a whole lot to read. There's a whole lot of context, a lot of history that I do not, I strongly recommend that you pay attention to, even if it's a give it a one cursory look. But take note that, in my opinion, having written the exams and helped a good number of people to pass, these are the very core of the conversation that you need to understand and keep sight of, don't lose sight of throughout your study in terms of the nature of the Constitution of Canada. Now we move to the sources. If you say that there's no question and I have your go ahead to advance the conversation. Do I have your go ahead to advance the conversation? So we move to the sources of the Constitution of Canada. Again, remember that the Constitution is not contained in one single document. And just like it sounds, the sources, pretty much means where do we derive, materials that have been pronounced or elevated to constitutional level. Does that make sense? The constitutional status. Where do we derive, materials or documents or concepts that have been conferred with constitutional status in Canada? And there are a handful of them. I'll run through them as quickly as I can. Hopefully you have your syllabus. Hopefully you also have your study material next to you. The first you probably see, is imperial statutes. And I say to my candidates, don't relax, Amaka, just relax. We're working through it. You cannot see it in your materials. You're muted. Are you good? Okay. So imperial statutes, I always say to my candidates, don't sweat too hard over this. Have a good understanding of what it is, but don't get soaked up in it. And what it means, just like it sounds with the word imperial, once you hear imperial, really, loosely speaking, it has something to do with the monarch in the UK or the monarch of the UK, right? And so what it really means in one line is that they are statutes, they are legislations that were enacted by the UK for Canada during colonization, when Canada was not an independent state, when Canada was a colony, or, was the British North American colony or colonies, right? So a number of those statutes, of course, upon assumption of independence or attainment of independence by Canada, a number of those statutes were repealed or, pretty much repealed. Maybe Canada, the Parliament of Canada passes a Canadian legislation to attend to what issues, a particular imperial statute covered, right? And so that imperial statute becomes repealed or gets repealed. But a number of them were retained. Does that make sense? So you still have a number of legislations that were enacted by the Parliament of the UK, the Privy Council, what have you, that are still in force in Canada. And then amidst those, you have a handful of them that have now been conferred with constitutional status. Does that make sense? So that pretty much is the, one-liner to explain. Even though that most definitely was more than one line, but that there is the concept or the idea behind imperial statutes being a source of, constitutional law in Canada. It pretty much is statutes that were enacted for Canada by the Privy Council of the UK and have now been conferred constitutional status by Canada itself. Does that make sense? Right. Next, you probably have Canadian statutes. So as well, a number of legislations that were, I think about 8 of them, a number of legislations that were enacted by the Parliament of Canada and have been pronounced and, elevated to constitutional status. Again, for the purpose of the NCA exams, those do not really, have a lot of weight. It's good for you to know it, be able to speak to it, but I won't advise that you, get soaked up or consumed by it. So we've reviewed imperial statutes, we've reviewed Canadian statutes. Next will be parliamentary privilege. This is quite an interesting one and slightly important as well. And again, because of Canada's close connection to the UK. Remember that the UK, I imagine that we're pretty much all familiar with the system of government in the UK. And the UK pretty much runs a parliamentarian system of government, parliamentarianism, where the parliament is supreme, right? Of course, there's no constitution, so the parliament is supreme. I believe only next to the Queen. So Canada retains, shreds of that in its system of governance. Does that make sense? Retains shreds, semblance of parliamentarianism in its system of government. However, it flips. The operation of parliamentarianism in Canada differs from the operation of parliamentarianism as we see it in the UK because Canada subscribes to the concept of constitutionalism. Does that make sense? And constitutionalism means that the constitution is supreme to everybody. So in Canada, I like to explain to my candidates that the structure, pretty much loosely speaking, is that the constitution is supreme because of the operation of constitutionalism, but right next to the constitution is the parliament. Right? Does that make sense? And it might be, an idea that we need to pay a bit more attention to. depending on where you're from or what other system of governance you have understudied, right? Because I mean, I studied in Nigeria. I understudied the system of government in Nigeria, and I know that, separation of powers is really strong because all arms of government, the judiciary, the legislature, and the what's the third one? Executive. Thank you, Amaka. Are equal. Does that make sense? Are of coordinate, authority and status and level. In Canada, because of that connection with the UK and that semblance of parliamentarianism and system of government that was retained by Canada from the UK, the parliament is superior to, quote and unquote, the executive and the judiciary. Very a bit of a complex structure going on there, because whilst the parliament is superior, the judiciary is still independent. Does that make sense? So the parliament cannot wield unnecessary influence on the judiciary, but in terms of structure, the parliament comes next immediately after the constitution. Now, the concept of parliamentary privilege just means that because of this context I've given you, because of this semblance, and shreds of parliamentarianism that Canada retains, members of the parliament in Canada enjoy certain privileges that are not reviewable by the courts. Does that make sense? And what that means is that they are not subject to the constitution. So even though I said the constitutionalism is here, the parliament is here, to an extent, the parliament still finds a way to stick out a bit, to a very, slight extent, stick out over the constitution. Does that make sense to you? Sana, I'd like to hear you. Oh, I think I lost you. You froze up. I interpreted that to mean that you got confused and I lost you. Okay, hopefully your network comes back and you join us. You see why I need to see your cameras? I need to see your faces. I can tell when I'm losing you or when something doesn't add up for you, and I can, zoom in on it. Okay, so I was saying that parliamentary privilege shows, it really displays a slight sweet spot there where the parliament is even, not subject to the constitution. Does that make sense? So you have the concept of parliamentary privileges, and really what they are is just that as members of parliament, you're entitled to certain benefits, certain protections, certain immunities that that you can exercise in the course of discharging your duties. Does that make sense? In the course of discharging your core duties as a member of parliament, you have some immunities, some protections that cannot be looked into, closely examined, reviewed by the court on the basis of the constitution. I'll give you a case. I'll review a case with you real quickly. It always animates the concept of parliamentary privileges a bit better for my candidates. And it's the case of Canada and Vade. When you start to study, you'd see it if you haven't started studying. Right? And what happened in that case, Canada and Vade, you probably want to note it down for when you start a study. It really animates the concept of parliamentary privilege. What had happened there is that a member of parliament had fired his driver. Does that make sense? Fired his driver, and the driver had instituted a matter, a suit in court, suing his boss or his ex-boss for summarily dismissing him, unjustly. Does that make sense? Now, in his defense, the member of parliament, of course, the matter is taken over, which is why it is Canada and Vade. The matter is taken over by the parliament because, of course, it's a member of parliament that's been sued. So the matter is taken over by the parliament itself. And the defense of the parliament was that, parliamentary privileges, or the concept of parliamentary privilege, covers that act of being able to hire and fire employees, and makes it immune to judicial review. Does that make sense? Are we good thus far? To say that we can hire and fire as we choose, and we don't have to make it, consistent or compliant with any laws, labor laws, or even in fact the constitution. Does that make sense? And the court, in reviewing that case says, whilst we agree with you, that parliamentary privileges are a constitutional concept, right? They have constitutional status. And the import really is that you really, as a member of parliament or as the parliament together as an entity, can take certain actions that will not be reviewable by the courts on whatever basis, whether on the basis of a legislation or even the constitution itself. Whilst we agree with you, we see the legitimacy of that concept, we must, delineate the scope of the operation of that concept. Does that make sense? And so the court had held in that case that you can only exercise these privileges or parliament in the line of your duty as a member of parliament in a way that affects your ability to discharge your core duty of legislation, or rather of legislating, I beg your pardon, as a member of parliament. And so the question was, how does your driver affect your ability to perform your duty as a member of parliament? Does that make sense? And so the court held that is too, far-flung from the core of your duty, and so that will not, be afforded the protection or the cover of parliamentary privilege. Does somebody want to say that back to me? I typically don't go on and on for this long. I've gone on for about 40 minutes. It's your turn to turn on your mics and say something back to me. I mean, does somebody want to say to me what you understand parliamentary privilege to be?
Parliamentary privilege, concerning parliamentary members, is usually the immunity they enjoy is usually restricted to their actions in respect of legislation.
Yes, in respect of their core duties, which is legislating laws, which is, if it is something that is closely connected, closely linked to your ability to discharge or perform your duty as a member of parliament, then, that can be afforded that protection. I mean, another case that comes to mind is the Nova Scotia Broadcasting Corporation case. Sana, can you say your name, please? Is it Sana or Sana? Am I saying Sana?
Yes, perfect.
I'm good.
You are, yeah. One of the few people who pronounced it right off the bat. So.
Right. So that case, did you want to ask a question? I saw you unmute your mic.
No, I'm good. I'm good.
All right. Okay. So that case as well. I mean, what had gone on real quickly in that case is that the broadcasting corporation of the province of Nova Scotia, on the basis of the charter, right, had decided that they wanted to take in their cameras and record the session of the Legislative Assembly of the province of Nova Scotia. Does that make sense to you? Like taking the cameras and record, have access to those sessions, record those sessions, the deliberative sessions of the provincial legislature. Does that make sense? And the provincial legislature had refused to say, we're not comfortable with you, recording us whilst in session, right? And the matter had gone up to the court, and the court had agreed to say that this is closely connected to what they do. This is the core of what they do: deliberation, enactment of legislations. If the Legislative Assembly of the province or the Parliament, in the case of the federal, government, says that we do not want you to come in with your cameras, I mean, on the face of it, if we're reviewing it by the law, by the Constitution, it is wrong, because you have freedom of expression, you have all of that going on in Canada. But because this is the Parliament and they enjoy certain privileges, the wisdom or the appropriateness of that decision will not be looked into by the court. The court is blinded by that immunity that comes alongside parliamentary privilege. So I'm giving you two cases: one that shows you a not so closely situated, action that didn't enjoy the protection of parliamentary privilege, and the core of the duty of the parliament, or rather in this case, the Legislative Assembly of a province, and attracted that protection of parliamentary privilege. Are we good? So in one line, parliamentary privileges are, benefits, or I don't want to use the word privileges, but immunities and protections, right, that members of parliament or members of legislative assemblies enjoy that are not judicially reviewable. So take note, they are not reviewable by the courts, as long as they are closely connected to the core of, the duty of the parliament, or the duty of the member of parliament. Right. So we move quickly to let me talk about royal prerogative before I go into case law. So royal prerogative, again, has its roots and history in the connection of Canada to the UK. I mean, just as it sounds, royal prerogative. And what it is like a remnant or the residual leftover powers that the crown had, leftover of the powers that the crown had and exercised whilst Canada was a colony of, the UK. Now Canada is independent, but the crown still retains, does that make sense? The Queen of England still retains some of those powers that she exercises in Canada, right? And those are called royal prerogatives. I mean, like I said on this call, the Queen of England is still till date the Queen of Canada, right? She's not physically represented here, but she's, her powers, these royal prerogatives are exercised on her behalf by, you have governor generals, you have, governor generals, and on the provincial level, skips me what they're called, I apologize. On the federal level, the representative of the Queen of England is called the Governor General. And I don't recollect what the representative of the Queen of England is called on the provincial level. Anyway, royal prerogatives is the residual, the leftover of those powers that the crown used to exercise in Canada, but still retains now that Canada is an independent state. Off the bat example would be, for instance, conferment of national awards, right? Foreign relation, diplomatic issues. Till date, the power to declare war is still contained in that royal prerogative exercised by the Governor General on behalf of the Queen. When you study maybe foundations and as you get more exposed to the entire framework of, the jurisprudence of Canada, of laws and all of that in Canada, you'd see how the truth is that it really is she's really just a ceremonial figurehead, and it really is just a lot of power play where it's the Prime Minister who practically handpicks who will be the Governor General, and the Governor General has to take recommendations from the Prime Minister. So it's not really like some very potent hardcore power that is still being exercised by the Queen of England. It really is just there, ceremoniously and just referentially, if that makes sense to you guys. Right? So that is royal prerogative. Again, it comes up in the conversation for sources of constitutional law. Why? Did you get my question? Do you want to attempt it? From the bit of conversation we've had in terms of explaining what royal prerogative is, why would you think it becomes important or necessary to review that in terms of, or in a conversation around the sources of the Constitution of Canada? I like the looks on your faces, at least the three of you that I can see. The reason, did you get my question though? Do you want to repeat my question to me? Did you get my question? Right, the reason it becomes important to have that conversation is that before now, largely those powers were not subject to judicial review. So remember, we're talking, what are the sources of the Constitution? Remember, the Constitution is really not subject to judicial review. The Constitution is the ground norm. So if anything becomes a part of the Constitution or is elevated to constitutional status, it means the court cannot say this is right or this is wrong. The courts are bound, by that, and have to use that as the measuring standard for every other legislation and every other act of government. Does that make sense? And we agreed up until this point. So if we're reviewing sources, anything that we, has been fortunate enough to make it into this conversation, pretty much what your mind should be playing around is, it means that this is constitutional and really cannot be reviewed by the courts in terms of this is, would you say the Constitution is unconstitutional? Do you get that? Because the Constitution is the yardstick for measuring every other thing, right? So the Constitution itself is not subject to judicial review. The only thing that can happen to the Constitution is that it can be amended. If it is not, as it is presently constituted, it is perfect. In fact, it is the yardstick for determining what is constitutional and what is not constitutional. So once we start having a conversation around what are the sources of constitutional law in Canada, at the back of your mind should be, this is a source. It has been elevated to constitutional status. That means it is almost untouchable. In fact, it is completely untouchable to the courts. Does that make sense? So the reason we're having this conversation with royal prerogative is that initially these powers, these residual powers, were not reviewable by the courts. It was more like a decree. The crown has decreed, that is it. Does that make sense? But in recent times, the jurisprudence has advanced so that to a very large extent, they are reviewable by the courts. And I like to tell my candidates that the hack to determining what is reviewable in terms of royal prerogative and what is not is how much the exercise of that royal prerogative affects your, a citizen's rights and liabilities. Does that make sense? Do you want me to say it again? Is it a mouthful? How much does the exercise of a royal prerogative affect a citizen's rights and liberties? And of course, it goes without saying, if it affects rights and liberties reasonably well, then it becomes reviewable by the court. If it doesn't as much, then it is still left in that honorary referential state. I'll give you a good example and I'll have you answer my question. I'll give you a scenario, I'll ask you a question and I'll have you let me know where your head is at with that. Take, for instance, conferment of honorary awards or titles and conferment of maybe Canadian passport or residence status, after complying with certain rules and regulations or obligations. Do you get that? On the one hand, conferment of residency status or Canadian passport after going through a process, a predetermined process. If you do this, you'll get that. You'll get the residency status or you get the citizenship status. Does that make sense? And conferment of honorary title. We see you, we think that you're doing good work in the province of Alberta, for instance, and we think that you deserve, the crown or the governor general wants to confer this award on you or confer this honor on you. Which do you think off the top of your head would attract judicial review? Are you
The
guys
latter.
still? I'm sorry, even I forgot what the latter is, Sana.
Sorry.
What's the latter? Okay,
The-
yeah. Citizenship and residency, and then
the citizenship.
fantastic. So you get it. I'm confident that you do. Does that make sense to you guys? Because I mean, this is a predetermined, you do this, you do that, you do this, you get that residency status, so you get the passport. Or we just seen you and we like what you do, would like to honor you. I mean, that's a very random, do you understand? Very, very deeply discretionary, do you understand, exercise. I mean, take note, a lot of royal prerogative powers are exercised discretionary, but if it closely affects your rights and liberties, especially where there's kind of like the semblance of a contractual duty going on there, do this for this. Does that make sense to you? Then the courts would be able to look into it. And that's why you have a lot of immigration cases in court. Else, the conferment of residence and citizenship for people who were not originally born in Canada, does that make sense to you, is an exercise of royal prerogative, is a discretionary power. Canada can decide today to say, we don't want you, we don't want new, we're not, conferring our residency status on anybody anymore. Does that make sense? But as of date, you say, if you do this, you do this, you do that, we will give you residency. If I do all of those things and you choose to withdraw that, part of your own obligation, then the courts can look into it, which is why we have immigration boards and all of that. Does that make sense to you guys? And I'm spending a bit of time on this because when I wrote my exams in 2019, I believe. I got a question. I mean, and that's why my posture, and I believe with a lot of tutors, with all the tutors on NCA guides, our posture is not, these are the questions. I mean, for instance, constitutional law, once you know federalism and you know charter, you are good, because those are the questions that the NCA will ask, right? And I know that that's very prevalent in our, in the NCA writing, internationally trained lawyers community. A lot of tutors say, I'll teach you federalism, I'll teach you charter, and you should be good. But when I went to write my exams, that was not the approach that the NCAs, presented. I had one 30-mark question that really was based on federalism. I'm not sure it was 30 marks. I think it was 40 marks. 40 marks question, fact-based question, federalism entirely. But then I had 10 6-mark short answer questions. Does that make sense to you? That made up for the rest of the 60 marks. So, I mean, there was a bit of chatter in there, but it was 6 marks. There was a bit of everything. So I got this question, this privilege, parliamentary privilege and royal prerogative question. I mean, again, 10 6-mark questions. So it's a 6-mark question, but not asking you to write 5 pages. Is hit or miss. You either know it, you get your marks, or you don't know it and you lose the marks. So the question was something along the lines of when are parliamentary privilege and royal prerogatives reviewable by the courts? Does that make sense? So if you hadn't zoomed in on it and soaked in on it, you would not even understand what the concept of judicial review, has to do with the sources of the Constitution. Talk more of being able to speak to when they're reviewable, or if they're reviewable or they're not reviewable. Does that make sense to you? So I like to zoom in on it with my candidates. Royal prerogatives, parliamentary privileges. Parliamentary privileges, one-liner, they are not reviewable by the courts. However, they must be exercised in a way that is closely connected to the core of your obligation. They must be critical to your ability to perform your duty as a member of parliament. Royal prerogative, on the other hand, are subject to judicial review. They are reviewable. However, you need to pay attention to those nuances. There must be a back and forth on which the court will, be able to assume jurisdiction to review. Are we good? Okay, case law. I believe, I think there's one more, but I will not probably review that because we've spent the last 1 hour on just chapter 1. And I'd said to you that we like to run through all the topics. I'm not sure I'll be able to do that. But I think we did a good job with chapter 1. So case law, very important as well. Case law as a source of constitutional law in Canada. I believe we all get what case law is. Saying, are you familiar with the common law or civil law jurisdiction? Which are you familiar with? Common law, civil law?
Common law.
Good. So I don't have to sweat or stress what case law is, right? We get case law, we get judicial precedent, the powers of the courts to pretty much enact laws, right? And how that becomes important in the conversation of sources of constitutional law is that in reviewing certain cases or in deciding certain cases, the courts have made pronouncements that have conferred constitutional status on certain concepts. Those concepts are called the unwritten concept of the Constitution. Unwritten constitutional concept. Does that make sense? You see when you start a study. And they are really just, a case, a person approaches the court with a case. The court in reviewing that case says, blah, 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 from our findings this, from our findings that. In fact, going forward, this concept, for instance, of democracy is a founding concept, legal concept of Canada. Does that make sense? It's a constitutional concept in Canada. It must be, referenced and complied with in every governmental decision. What that says to you automatically is democracy has become an unwritten concept of the Constitution. Does that make sense? Does that make sense? Does that speak to how case law can be a source of the Constitution? Again, just the very weight of it should inform you that the courts certainly need to exercise caution in making those pronouncements. Does that make sense? In making pronouncements that can confer constitutional status on anything, on any concept. Do you understand? And it also says to you that the court would only make those pronouncements based off of, hopefully, their in-depth understanding of the entire constitutional framework and jurisprudence of Canada. Right? So going off of sections 91 and 92, like we discussed under the 1867 Constitution, if the court in reviewing a case declares expressly that federalism is a constitutional concept in Canada, that won't be too out of place. Does that make sense? Because we already have sections 91 and 92, of the 1867 Constitution, that, pretty much speaks to that, even though it doesn't expressly use the word federalism or federal state. Does that make sense? So, when you go to study chapter 1 in reviewing the sources, please review I believe is the secession of Quebec case. It's a case I like to talk on, but I'm not sure that we have the time to. But if you review that case, and just as it sounds, Quebec had attempted to secede. The federal government had approached the courts to say, can Quebec really secede without our permission, right? Without our consent? unilaterally. Does that make sense? And, I put forward a couple of questions to the court. So again, the references and the cases, right? References usually is the court approaching, I beg your pardon, the government approaching the court to say, there's no issue, or an issue is brooding, but it's not yet, fully degenerated and dilapidated to the point where we want to file a suit. Does that make sense? Or we're contemplating a legislation, we're contemplating an action, and we'd just like to get your inputs. It's not a common mechanism between the legislature and the judiciary in a lot of other climes, but it's very common in Canada, where the government, the legislature or the parliament can approach the courts to say, we have a couple of questions on this issue. Advise us, or what are your thoughts? Speak to it. Those are references. Does that make sense? So the parliament had approached the courts to say, this issue is going on. Very political, no legal issues, particularly yet, but we would just like to know where your head's at in terms of your understanding of the laws, the constitution, the role that you play. What do you think? Advise us legally, pretty much. Those are references are, and that was what had happened in the reference secession of Quebec. Quebec is attempting to leave. They've, passed a referendum, already been voted on. They really want to leave. We don't want them to leave. We don't think they have the power or the authority to secede unilaterally. All courts, what do you think? Right? And in reviewing that and getting back to the government, the courts had come up with a number of concepts that the court pronounced to be constitutional concepts. Democracy, in saying that if Quebec passes a referendum in Quebec within the province, and the result of the referendum is 51 people vote that yes, we want to leave, the dominion of Canada, we want to secede, and 49 say no, we should stay. That's a majority going on there, and we have to respect that, because we're essentially at the core of, Canada, a democratic state that will not, turn a blind eye to such significant representation of majoritarianism. Does that make sense to you? To say that if the province has passed the referendum, majority of the people in that province have said they want to leave, why would we forcefully hold on to them? So democracy was pronounced to be a constitutional concept in Canada. You would not find it in any of the written documents that make up the Constitution. You will not find anywhere where, there's an express declaration that Canada is a democratic state. Does that make sense? But essentially in reviewing, the style of governance, the laws, just in being in tune with the essence or the core of the country, of the dominion, the courts, the Supreme Court had enough authority and jurisdiction to be able to say that we believe in democracy. Don't we believe in democracy, federal government? Are we not a democratic state, right? Are we not a state that protects minority rights? Are we not, a state that, again, another fine example of case law being a source of constitutional law would be the independence of judges. That concept was pronounced upon by the courts. You will not find it written down anywhere, but the courts in reviewing a case are declared that independence of the judiciary is non-negotiable in Canada. Does that make sense? If we want to sustain, if we want to sustain sanity, if we want to sustain cohesion, and the semblance of a sane and modern community or state, then the judiciary's independence must be protected at all costs. So that way, independence of judiciary as a legal concept got elevated to constitutional status. Are we good? I'm giving you about 2 examples, animated examples of how case law, contributes to the constitutional law jurisprudence in Canada. And I believe we've done a pretty thorough job with chapter 1. I'm not sure that, I believe the sessions were supposed to be an hour long. I'm not sure how much we can run through the other topics. But chapter 2, I'll give you one line. Chapter 2 is nothing scary, nothing to don't let it subsume you. Don't let it take a lot of your time. What I advise my candidates to do is print out sections 38 to 44, I believe. 38 to 49. Print them out if you can, right? Take them with you to the exam hall. Read through it by yourself. It's simple English. It's not drafted in archaic legalism, or rather legalese, like a lot of, maybe our own countries draft our laws, right? It's very simple English. And remember, we had the conversation whilst we're trying to trace the history of the 1867 Constitution to say the 1867 Constitution didn't provide for amending procedures, such that if Canada needed to amend anything, they needed to consult with the UK. And then we said that the 1982 Constitution brought in and introduced amending procedures. These are those amending procedures. So that should also tell you, anytime you think amending procedures, what you're thinking of is Constitution Act 1982, sections 36 to, rather 38 to 49. Constitution Act 1982. I'm wondering why I'm leaving. Oh, okay. Right? So you read those, there are about 5 of them. There are 5 of them. Read those, sort them out, nothing scary. Right? I'm unable to descend into the details of it, but my tip, my hack, read the provisions of the Constitution itself. Read those sections from the Constitution itself, right? Chapter 3, Federalism. I'll give you a one-liner that I believe is important. Again, we've kind of reviewed federalism in Canada. We've spoken to the source and why Canada is a federal sections 91 and 92 divide powers between the federal and the provincial government. Very important feature of distinguishing feature, right, of Canadian federalism from classic federalism is that in Canada, the federal and the provincial government have coordinate authority. Does that make sense to you? I'll say it again. Both levels of government, federal and provincial, see, innately I already have my hands this way to show, subordinate authority, because this is, what a lot of federal states have going on. But in Canada, it's this way. It's coordinate. The federal is not superior, at least in theory. This is what Canada preaches to be Canadian federalism. The federal government is not subordinate to the provincial government, which is pretty much, in theory, what you have going on in the US, in America. The state governments pretty much wield, all the important powers, right? Or, I apologize, I'm Nigerian. In Nigeria, where the federal government, this is what you have. The federal government is the boss and the state governments are subordinate. In Canada, which is typical of a lot of classic federal states, right? There usually is some form of, subordination structure going on. But in Canada, Canada preaches coordinate. You say that coordinate authority. So the federal and the parliament are par in terms of authority. That's my one-liner for chapter 3. There's a mouthful of conversation when you read your study materials, you'd see, but that is very important. It's very important that you understand that. I'm not sure that we can run through all 20 chapters. Chapter 4 is a very, probably the core, one of the cores of the course. But I will also just say to you, chapter 4 in your syllabus, I believe is judicial distribution of powers. Is that what it is in the syllabus? Do you still have your syllabuses? Judicial review and principles of interpretation, right? And what that is, again, remember I said that everything that you study in constitutional law, ask yourself, how does this inform constitutionalism or the operation of constitutionalism in Canada? Again, remember constitutionalism is a style of governance that dictates that the Constitution is king, that the Constitution is the measuring standard for every other governmental action or legislation. And what that means is that there needs to be a body, an organ of government that does that measuring. Does that make sense? That uses the Constitution to measure, that uses the Constitution as the measuring yard. And what that measuring and review, is it consistent with the Constitution? Is it unconstitutional? Is what it is called is judicial review, right? So that essentially is the concept of judicial review. It is the court reviewing, closely examining, inquiring into the core or the nature or the component of a legislation or a governmental action for the purpose of determining if it is consistent or compliant with the Constitution. In this case, because we're reviewing constitutional law, our main measuring stick, as I've been saying, is the Constitution. If it wasn't the Constitution, if we're just talking, in terms of in terms, if we're just talking generally, the roles of the court, it will be reviewing to ensure compliance with a particular legislation. Does that make sense? So that if you don't comply with that legislation, then that action is declared to be illegal, the penalties, sanctions. For the purpose of constitutional law, the court is reviewing for the purpose of determining compliance and consistency with the Constitution. So that's the concept of judicial review, manned by the courts, right? And then you have the principle of interpretation. They're saying, how does the court interpret, on the one hand, because to review a governmental action or a governmental legislation, you have to have an in-depth understanding of that governmental action and legislation, right? As well as the Constitution that you're going to hold it up against. Have I lost you guys? Does it make sense? Right? So that is where the principles of interpretation comes in. The court now says we need to come up with principles, guidelines that will help us interpret for the purpose of, really understanding in-depthly what this law that is being impugned or that we're being asked to review is. And in fact, the Constitution itself that we're supposed to hold this law up against, what exactly does it mean? Right? Off the top of my head example would be the same-sex marriage reference, where the court had been approached to say, please, what exactly does marriage mean in the Canadian jurisprudence, considering that this legislation, right, had defined marriage in maybe the 1960s, right? But now, obviously, right, obvious to everyone, the community called Canada has advanced over time to the point where this concept of marriage, or this definition of marriage that was provided for in this 1960-something document, can no longer still be what we're working with. Does that make sense? And so the court has to come up with principles that will guide the court, and ensure some consistency in its style of interpreting either the Constitution or impugned legislations that come before the court for judicial review. Does that make sense? So there, I've kind of demystified what that topic would be about, or what that chapter would be about, and then we now unpack it. There's an entire lot to unpack under chapter 4, an entire lot that I'm not sure that we have the time to, or if we do, we will not be able to look at the other chapters, give an overview of the other chapters. An entire lot going on in chapter 4. But those are the things to have at the back of your mind. Judicial review, how is the court ensuring that this law that is being complained about, or this governmental action, the police has arrested me, is that constitutional? Does that infringe on any of my constitutional rights? How does the court, answer that question? How does the court review that governmental action of arresting me? Or this law that says, blah, 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 and I'm complaining about, how does the law review that law, holding it up against the Constitution for the purpose of determining, its consistency with the Constitution? Does that make sense? Right? Chapter 5. We have somebody do you want to tell me what chapter 5 is about? Federal paramouncy. Now, there's absolutely no way to review chapter 5, no matter how cursory, without still going back to chapter 4. Right? And we've talked about judicial review, and very quickly, what the court does in terms of judicial review, remember that we said that 1867 Constitution provides for federalism, right? So it's a constitutional issue concept. Every action, every legislation must be constitutional in terms of 91 and 92. They must comply with 91 and 92. And what that means, as basest as I can put it, is that if this subject matter is listed under 91, for instance, banking, right, is federal, listed under 91 to be competent to the federal government, then the province has no business regulating banking or enacting a legislation that attempts to regulate banking. Does that make sense? All right. So that essentially, in one line, is the entire concept of judicial review on federal grounds. There is an awful lot to unpack, right? But that gives you just the framework or like a cushioning for when you start to do your study. What you're looking at is you're reviewing, the court is reviewing on federal grounds. Federal grounds mean federalism, which says we have 2 levels of government. You can do this, you can do that, right? So if you are doing what you're not constitutionally empowered to do, then it is most likely going to be held to be unconstitutional. And if you're also doing what this is supposed to do, then it is, do you understand, upon judicial review to be held to be unconstitutional. That in one line is a summation of Chapter 4, judicial review on federal grounds. And then I also typically say, when you start to unpack, you'd see that a a constitutional challenge to a legislation on federal grounds can take 3 forms: validity, applicability, and operability. Now, please write this down. It will make absolutely no sense to you for now, but when you start to study, it makes sense to you. A constitutional challenge to a legislation takes 3 forms. On federal grounds, I beg your pardon, constitutional challenge to a legislation on federal grounds can take 3 forms. Number 1, validity. In front of validity, please put a dash or an hyphen and write the pith and substance doctrine. Pith, P-I-T-H, pith as in the core of I believe is a peach, the fruit, right? The core of the center, right? Pith and substance, the substance was the meat of this matter. So in front of validity, pith and substance doctrine. Number 2, applicability. In front of applicability, after a dash, please write the interjurisdictional immunity doctrine. Right? And then number 3, operability. How operable is this something, or is this legislation? And in front of that, I think federal paramouncy, the doctrine of federal paramouncy. Are we good? Now, are we good? Have you guys got it? Right. So a challenge to a legislation can be impugned to say, for instance, if the federal parliament has passed this legislation that says XYZ, I'm uncomfortable with it. All courts, I'm impugning it, please review it. Does that make sense? Does the federal parliament have the powers? Remember, all of this is on federal grounds. All of this is based off of 91 that provides that the federal parliament can only do XYZ, and 92 that provides that the provinces can only do ABC. Does that make sense? So if, for instance, the province passes a law that really looks like an X law, remember XYZ is for the federal parliament, ABC is for the province. Now the province passes an X law, right? That law can be challenged at the courts to say, on the grounds of federalism, on the grounds of 91 and 92, that provides that the parliament should regulate XYZ and the province should regulate ABC. Why is the province enacting an X legislation? Does that make sense to you? Now, that is the question of validity. If the province is supposed to legislate over ABC and the court finds that, in fact, this legislation that I've challenged is in fact, in relation to X, which is clearly for the federal government, then the court will say, oh, province, you have overstepped your bounds. You are functioning outside of jurisdiction. You are functioning, or you've passed this law outside of the scope of your constitutional authority, constitutional legislative authority. So this law is an invalid law. The import of an invalid law is that it is completely unconstitutional, cannot be remedied in any way, and is dead on arrival. It's treated as though it was never passed because you have acted without power. You have acted outside of the scope of your constitutional power. Remember, our analogy is ABC for the provinces, XYZ for the federal parliament. Does that make sense? The same way, inversely, if the federal parliament passes a B law, they have overstepped their boundaries and are usurping provincial constitutional legislative authorities. So a B law enacted by a federal parliament will be invalid, dead on arrival, unconstitutional, treated as though it was never enacted. That is the question of validity. And I said to you, write down the doctrine of faith and substance, right? The faith and substance doctrine, because that is the doctrine that the court uses to determine if the legislation is in fact a B legislation or an X legislation, right? So the court reviews the legislation, like, just like we do contract reviews and legislation reviews as well. You read a word page by page, right? What is this talking about? What is at the core of it? What is the central idea of this legislation, which is where PITH, P-I-T-H, comes from? What's the subject matter of this legislation? What's the most compelling? What's the most prominent, dominating feature of this legislation? In doing that, in deciding what that is, the court is able to take evidence even outside of the document and say, tell me, what were you thinking? Or whoever has been indicted, whether it's the federal parliament or the provincial legislative assembly, province of Ontario, what were you thinking? What informed your decision to enact this legislation? Was it because you really wanted to regulate banking somehow? Can I see evidence into your enactment deliberation sessions? Does that make sense to you? What conversations were you having on the floor of the House when you decided that you needed to enact this type of law? All because the court is trying to determine you're muted, I can't hear you.
Validity.
Pardon, can you say that again? The court is trying to determine the
validity.
Validity, but first trying to determine what the legislation is in fact about. Because it is what the legislation is in fact about that will now help the court be able to classify it, to say, okay, it really is a B legislation and it is competent to the province. Or no, it looks like a B legislation, but upon closer review, it in fact is an X legislation, so it is competent to the federal parliament and not you. Does that make sense, guys? Does it make sense? It's a bit of a mouthful. It can really get complex because there are a bit of overlaps here and there, but essentially that's the framework. 91 lists out XYZ for the parliament. 92 lists out ABC for the provinces. Everybody stay in your side of the street. Does that make sense? If you cross over to my side, then your legislation, if the court determines that you have crossed, you have usurped, you have gone outside of the scope of your constitutional authority, then your legislation will be invalid. A lot more to unpack, a lot of interesting authorities, case law that animates it, that gives it effect, that makes it come to life, right? We don't have the time to look into that. But again, I said that the faith and substance doctrine helps the court to determine what the legislation is about. That will now help the court determine if it was in fact a valid law, if it was in fact enacted by the legislative body that had the constitutional authority to enact such a legislation. Are we good? Right? Then we move to applicability. I mean, I didn't plan that. I didn't think we're going to do this, but to have a conversation on chapter 5, we have to touch on it. We move to applicability, and applicability just says that applicability joins the challenge kind of like midway. Validity is the start. If it's an invalid law, it's dead. It's dead. You don't have the power to do it. Don't do it, right? Applicability joins the challenge midway. Applicability says, I have some feedback. Juliana, I think that you probably came in on 2 devices, or somebody's on 2 devices. You need to mute one. I have some feedback. I can hear myself. Okay, it's better now. Thank you. I lost my line of thought. Validity starts from the start to say, should this even have been enacted to start with, right? Applicability joins the challenge midway to say, oh, I say it's a valid law. I have no problem with the validity. It was enacted by the appropriate enacting body, right? However, I'm just wondering why it should apply to me specifically. Does that make sense to you guys? And with that conversation, it's a particular crop of people that are able to trigger that question. Again, I mean, whatever prayers you said this morning before coming for these classes, just as an aside, it worked. Because we're really unpacking the core of the course. This was not the plan, right? again, just a particular crop of people are able to trigger that conversation. It's a valid law. It was enacted. I mean, back to our analogy, it's a B law, and it was enacted by the province. The province has the powers to enact ABC laws. Are we good? And this is a B law validly enacted by the province. But I come up and say, I'm not contesting the validity of this law. I'm not challenging the validity of this law. It's a valid law. It is generally applicable to every other person, but I'm special, I'm different, and I don't think it should apply to me because I'm just hot, right? Right? Now, these hot guys typically are these hot guys are typically federally regulated undertakings and federally incorporated companies. Do you get that? Federally regulated undertakings and federally incorporated company. Remember I said that for the question of applicability, write down interjurisdictional immunity, just as it sounds. These hot guys, by their nature, inherent nature, are subject to two jurisdictions, subject to both the provincial jurisdiction and the federal jurisdiction. It gets a bit complex here, right? You have to follow me closely. So they are by their nature interjurisdictional. International means two or more nations. Interjurisdictional means you're subject to, in this case, it's not two or more because it's just two levels of government we're dealing with, federal and provincial. So it means that these entities, these hot people, are subject to both authorities. They're answerable to both the federal and the provincial government. And so they're like, I see this provincial legislature, I see it's valid, I see it applies to every other quote unquote provincial entity, right? And that should include me ordinarily. But at this point, I might have to call for help. I might have to claim some immunity because, I mean, I have to comply with the federal one. And now you're coming with this one. This provincial one is going to, the phrase there is that it is going to impair, a vital part of my operation. Impairing means it is going to adversely affect me. What that means is that if it is merely going to affect me, then I'm still subject to that law. Remember, I'm interjurisdictional. So I'm subject to the federal laws. I'm also subject to the provincial laws. You look like I'm starting to speak French. Is it making sense? I mean, I can't see every other guys. So instinctively, I'm just focused on Amaka and Olabisi and Sena up until a few minutes ago. I cannot see Sena anymore. But hopefully all of the other guys on the call that I cannot see, hopefully you don't feel left out. And if you have a question, you can turn on your mic and interrupt me one more time and ask your questions. So remember we said that the question of applicability joins the conversation midway. Validity is the start point. Is this law even constitutional to start with? If we've answered that question in the affirmative, yes, it's a validly enacted law, it is constitutional, then we hot babes can come and say, right, this law is valid, it's generally applicable, but because we're just really special and cute, we don't think it should apply to us. Now, I've said that the cute people are typically the federally regulated undertakings and federally incorporated companies. I'll give you a bit of context and so it'll probably be clearer, Amaka. Federally regulated undertakings are largely interprovincial business operations. Interprovincial means that, meaning that they operate in more than one province. Finest examples are like transportation companies. Again, not just local transportation companies, like for instance in Ontario, MI, Mississauga Way, that is just Mississauga, right? But if you have or in Alberta, Calgary Transit, that's just Calgary, right? But if you have a transportation company, finest example are airlines, right? Or even land transportation companies that ply 3-4 provinces, right? Or trains, or right, privately owned. And then I run a bus company. Unfortunately, I don't have any examples of any of such companies, like their names. But I know that you have buses that can take you maybe from closely situated provinces, right? Now, the question is, which province should regulate such a company? Do you understand? Because I apply Alberta, I apply BC, I apply Manitoba. should all three of them be slapping me with legislations and regulations? Do you understand? So because they're interjurisdictional, they are somewhat elevated above the provinces to become federally regulated. Does that make sense? So that's what you call federally regulated undertakings, FRUs, federally regulated undertakings. They're private essentially, but because of the nature of their business, you almost cannot subject them to just one province. So they're regulated by, quote and unquote, the big brother, who's the federal government. Now, that should also trigger that conversation of coordinate authority. Is there really, truly, in practical terms, coordinate authority in the Canadian federalism? But that's a conversation for another day, right? But that's essentially what happens to the federally regulated undertakings. Another fine example are telecommunication companies. There's Bell here, there's Bell there, there's Bell everywhere, right? Who should regulate Bell? Federally regulated. Does that make sense? Now, take note, the fact that there's Bell here, there's Bell there, and Bell has now, we've agreed that Bell has now been elevated to be federally regulated, does not mean that if a Bell car, company car, is driving on a provincial road in Ontario, and the speed limit on that road says 70 kilometers per hour. So you will not say, because I'm Bell, I'm federally regulated, I can blast 150 kilometers. You are still subject to provincial legislations to a very decent extent. You see the interjurisdictional component coming in now. I feel bad that this is a free class, right? But hopefully you guys get it, and hopefully it opens up better when you start to study. So you see the interjurisdictional component coming on now. They're federally regulated, but they're still subject to validly enacted provincial laws to an extent, right? Now, when those validly enacted provincial laws begin to impair, very important word, impair, I-M-P-A-I-R, meaning that they adversely, affect, then they can cry foul and approach the courts to say, you know how we are, we're federally regulated, we're interjurisdictional. We agree that ordinarily validly enacted provincial laws are applicable to us as well. This particular legislation that we're impugning and challenging, we also agree, we concede that it is validly enacted, it's a validly enacted provincial legislation. However, because of our special and unique nature, we're challenging the applicability of this legislation to us. Does that make sense? Right? And so the court triggers the doctrine of interjurisdictional immunity. So it's an immunity that you can claim because you are interjurisdictional. And the measuring yard for when the court will actually afford you the protection of that immunity is if the provincial law is going to impair you. If it's not going to impair you, go home and comply with both. Because after all, you're making money from everywhere. I mean, as an aside, right? So if it's not going to impair you, federally regulated undertakings, you are subject to both laws. Both laws are applicable to you. Federal laws are applicable to you. Provincial laws, in the provinces that form the seat of your businesses are applicable to you as well, largely. But if you're able to convince us that this provincial law is going to impose such an unbearable burden, or is going to, affect you adversely, affect your business, the operation or the management of your business adversely, then, we'll look into it and afford you the protection of interjurisdictional immunity in declaring that this otherwise valid law, otherwise generally applicable law, will not apply specifically to you. I believe that we should end the class on this note. Okay, I'll throw in chapter 5 because chapter 5 was the reason I went into this conversation in chapter 4, because you cannot have a conversation around chapter 5 if you don't have this background. So we've talked on validity loosely. We've talked on applicability loosely. Somebody asks you, what's the peace and substance doctrine? You can give at least a line or two. Somebody asks you, what's the interjurisdictional immunity doctrine? You can give at least a line or two. Then we talk about federal paramouncy. Federal paramouncy is operability. It helps the court determine, I beg your pardon, just 1 minute. Okay, I mean, I apologize. I was so subsumed in the conversation. I didn't realize there was somebody having a full conversation in my background. Right, okay, but I think it's quiet now. So the question of operability, remember we said 3 questions, 3 challenges potentially to a legislation. Validity, is it valid? Applicability, is it applicable to me? Take note, a valid law is generally applicable. Does that make sense? If it's valid, it is constitutional, it's generally applicable. So applicability can only become problematic in terms of specific hot babes, right? FRUs, FICs. Now, operability now says that there's a challenge. There are 2 levels of government. Both levels have enacted a legislation in relation, validly enacted a legislation in relation to the same issue. By the time you start a study, or if you come to my paid classes and we unpack these issues, unpack 91 and 92, you'd see that as much as we've said that there is an exclusivity in terms of ABC, XYZ, stay in your lane, there are also areas of overlap. There are also areas of overlap where, the Parliament can enact a legislation validly on an issue that the provinces can also enact validly on. I mean, we don't have a lot of time. Off the top of my head, I would have given you a section, I believe it's sections 92. If you read 91 and 92, you read, if you give me a minute, I'll consult my notes because for some reason it's flown out of my head, right? If you read 91 and 92, the explicit provisions of the Constitution that expressly declare that both levels of government can legislate in respect of certain issues. Does that make sense? 92A sub 3, 94 sub A and 95. Did you get that? 92A sub 3, 94A, and section 95 of the 1867 Constitution. If you read those expressly, it provides for concurrent powers. It says both the Parliament and the provincial legislative assemblies can legislate in respect of, I think, things like agriculture, and a couple of other things, right? Expressly, concurrently. Do you understand? Express provision of concurrency. So, and a couple of other very important issues that we need to unpack. But expressly in terms of what is even contained in the Constitution, in the language of the Constitution, you see concurrency going on there. And concurrency is what gives rise to the question of operability. To say that the Parliament has enacted this legislation saying thou shalt not validly. The province has also enacted this legislation saying thou shalt validly in respect of the same issue. So there's an express contradiction going on there, right? Who do we obey? Which of the laws do we comply with? Do you see that going on there? So which is operable? Do you also see that if we have gone past the conversation of are both laws valid and there is no contradiction, do you appreciate how the courts will say go home and comply with both? Because they're both valid laws. Does that make sense? So that's called the ultimate harmony, the concept of ultimate harmony in Canada, where both the federal and the federal government and the provincial government validly enact different legislations in respect of the same issue that they, have the constitutional legislative authority to enact in respect of, and they are both saying the same thing, right? The legislations provide for this almost substantially the same thing. The legislations are harmonious. So in Canada, that is referred to as ultimate harmony. Does that make sense? However, and so what the court will say is dual compliance is possible. Go ahead and comply with both. However, the question of operability comes up where we see a validly enacted federal legislation and in respect of issue A, and an equally validly enacted provincial legislation in respect of issue A. But the federal parliament says, do not. Provincial legislative assembly says, do. So you're in a fix. If you obey the provincial legislation, you're going to be in breach of the federal legislation. If you comply with the federal legislation, you're going to be in breach of the, so dual compliance is not possible. Another instance is where the purpose of the federal legislation will be frustrated. So express contradiction, if you're taking notes, underneath operability, just write that, the question of operability arises as a result of concurrence of legislative powers, right? Concurrence of legislative powers, results in the enactment of two valid legislations in respect of the same issue by both levels of government. Now, if both legislations are harmonious, right? Dual compliance is possible, there are no contradictions, then you're good, comply with both, there are no issues. Both are in operation, both are valid, both are applicable. If, however, there is an express contradiction, then there's an issue. Express contradiction can take two forms: impossibility of dual compliance or frustration of federal purpose. If you have any of those two going on there, then you have to approach the courts to say, see what's going on here. What do I do? And then the court triggers, and then you have triggered the question of operability. What you're essentially asking the court is, which is operable? Does that make sense? The federal or the parliament, or rather the federal or the provincial legislation, which is operable? And to answer that question, the doctrine that the court triggers is a doctrine of, even though I cannot hear you, but I read your lip. And I imagine you said federal paramouncy. The doctrine that the court will trigger to answer the question of operability is the doctrine of federal paramouncy. And just as it sounds like an English speaker, plain English, what do you think federal paramouncy means? Olabisi, I haven't heard you. I mean, now I can see your entire face. Initially, I could see just your forehead and a bit of your glasses. Now I can see you. What do you think for the doctrine of federal paramouncy, what do you think that doctrine is? Or how do you think it will play out?
Okay, in this instance, I think the court would give paramount position to the federal legislation in this contradictory.
Goodbye. Right? Because I mean, fantastic. That's exactly what it is, right? The courts will treat the federal legislation as paramount, over the provincial legislation. And I mean, I apologize that we were unable to run through all of the chapters, but then I'm sure that the ones that we ran through, we did a bit of an more in-depth than I anticipated. Of course, the NCA guides offers. Amaka, you look like you have a question or you have a comment. You're muted though.
I have a question. Why would the court give to federal government paramouncy?
So
because
yes.
They are coordinates. So why?
Fantastic. I mean, that's a very fantastic way for your mind to work. But that just tells you that, it takes you back to the way I presented the coordinate authority Canadian federalism issue to see that it's on paper. Right? Take note. If you pay close attention, even in the conversation around interjurisdictional immunity, it usually is the provinces who bear the brunt. Were you able to drain that from the conversation around interjurisdictional immunity? It usually is the provincial, legislations that the court would say is inapplicable to federally regulated undertakings. Does that make sense to you? Does it make sense to you? So remember, the FRUs have come to say we're interjurisdictional, we will comply with what federally regulated, but we also know that validly enacted provincial legislations apply to us. However, this one is about to strangle the life out of our business, right? So the court would say, okay, we see, we agree, it impairs, so this provincial legislation is inapplicable to you. Again, the provinces have to kind of take the hit. Do you see that? And on paper, I mean, if you read in depth a couple of decisions, government court decisions, you see the court saying, yeah, it's a reciprocal doctrine. That's specifically the doctrine of interjurisdictional immunity. The court will say it's a reciprocal doctrine. If it's the other way around as well, a provincially regulated undertaking, the federal government will be restrained. Do you understand? But in the wealth of the jurisprudence that we have of cases, decided cases that we have that speak to the IJI doctrine, the doctrine of interjurisdictional immunity, almost 99% of those cases, it's the provincial legislations that eventually get declared to be inapplicable to federally regulated undertakings. So, I mean, again, I decided to take a bit of time to speak to it because, again, in my exams, when I was running my exams in 2019, I got one of my, remember I said I had 140-mark fact-based question and 10 6-mark short answer questions. One of those 10 questions was exactly this question Amaka had asked, to say, in light of the concept, in light of the existence and the operation of the concepts of, interjurisdictional immunity and federal paramouncy in Canada, speak to or critically review the concept of Canadian federalism. Does that make sense? I mean, I'm not even sure that the question was even that, hand-holding. I think he just said critically review the concept of Canadian federalism. First of all, if you don't know that there's a uniqueness to Canadian federalism separate from classic federalism, you've lost those 6 marks, right? And that unique feature is just the idea of coordinate authority as against subordinate authority, which is, significant or peculiar to or characteristic of classic federalism. Now, in reviewing that concept of coordinate authority that Canadian federalism preaches, you have to touchlight these issues to say, yes, Canada believes that its version of federalism, advocates coordinate authority between both levels of government. However, in the court's application of doctrines like federal paramouncy, what does federal paramouncy mean? How do you, in one breath, say coordinate authority, and in the next breath, say federal paramouncy? Does that make sense? So, fantastic question, Amaka. It just shows you, that the nuances, even though on paper, Canadian federalism is coordinate authority, right? But as you understudy the entire jurisprudence, you zoom in on tiny details, you start to see loopholes, you start to see inconsistencies, right? But it doesn't change the fact that, certainly the federal government in Canada cannot lord it over provincial governments, like, for instance, what you have in Nigeria with the federal and state governments. Does that make sense? Any other questions, comments? I mean, almost 2 hours. It was supposed to be a 1 hour call. Hopefully it was helpful. Hopefully you're more excited to go back to your materials to start studying. Hopefully when you start to read these concepts, it saves you time, the initial time where it sounds like Greek and you're just like, what exactly are you talking about? Hopefully, it's familiar and it more easily makes sense. Okay, barring any questions, Sana, no, I took so much credit for knowing how to say your name off the bat, and now I'm lost. I mean, I cannot see you again. I think I derived inspiration to say your name right because I could see your name. I kind of just drew, because I could see your face. I kind of just drew inspiration from your face, but I cannot see you anymore. Hopefully you're on the call. I wanted to say a special thank you to 3 of you guys, Sana, Olabisi, and Amaka, because you guys had your cameras turned and I could see your faces and you made me feel like I was having a conversation. You made it easier for me. So thank you, ladies. Right? And thank you, every other person, for your time, for being... Okay, Olabisi, did you have a question? Please.
I just wanted to ask, is there any scenario wherein this time it's not between the federal and provincial, it's between maybe provincial legislations?
In terms of interjurisdictional immunity?
Yes. No. Okay, so it's only just, okay.
Yes.
Thank you.
Only just, a contradiction, or maybe not a contradiction, but for federally regulated undertakings, remember, a federally regulated undertaking is most likely present and operational in different provinces, right? So you can challenge the applicability of an Alberta law in Alberta, Bell, our example, and you can still challenge the applicability of an Ontario law, for instance. Do you understand? In Ontario, Bell. Does that make sense? To say that, we don't have this kind of law in Alberta. We don't have to deal with this in Alberta, but we have to deal with it in Ontario, or a completely different issue. So it's per province. Does that make sense to you? But good question. Fantastic question. Even Amaka agrees with me as the tutor that your question was a question. Cynthia, I was going to tease you to say, were you looking to get my thank you as well? Because I was saying thank you to guys who turned on their camera. I will say my thank you to you because... Or did you have a question? You're muted.
Yes. I was just about to ask you a question. That's why I wanted to make sure I put the question together. Okay, so from what you just said about this federal paramountcy, I just want to make sure I got you clearly. You said if a provincial law frustrates the purpose of a federal law, then the provincial law must yield.
Yes, absolutely.
Oh, okay.
Okay. And I mean, I know that we did a fantastic. I mean, I feel like all of you on this call are super smart. It'd be nice to have you in my class. I feel like
Yeah,
we'll have very productive conversations, because all of the questions you've asked me are very intelligent questions. And we didn't pay a lot of attention to frustration of federal purpose, which is why I'm excited that you highlighted it. We paid a lot more attention to impossibility of dual compliance, where it's glaring. The federal law says do this, the provincial law says do not do this. But in terms of frustration of federal purpose, I'll give you a case and it will animate it. I apologize, I don't recollect the title of the case off the top of my head, and I don't have the time to consult with my notes now. But the fact of the case is this. There's a bankruptcy legislation, two bankruptcy legislations. The federal bankruptcy legislation says if the company has defaulted, right, do not give it any notice. Or bank, do not give the company any notice before you go to liquidate its asset. Does that make sense? The provincial legislation says if there's a default, give the defaulter maybe 3 weeks of notice before you go to liquidate its assets. In terms of dual compliance, do you agree that dual compliance is possible? Because the federal legislation is not penalizing you for giving notice. It just says you don't have to. There's no requirement to give notice. So if you choose to give notice, that's your business, right? So dual compliance is possible. Does that make sense? It doesn't prescribe the giving of notice. It's just silent. It doesn't have any requirements to give notice or not to give notice. It's not like if you give notice, you're in trouble. If it was that, you give notice, you're in trouble. The provincial one says give notice, then there's express contradiction. But in the case, in that particular case, the federal law, and I might be misplacing it, right? It might be the provincial law that says gives notice, but get the concept, the main idea. One legislation is quiet as to notice, just says you can go right ahead and liquidate the asset upon default. The other one says give some, prescribed period of time as notice. In that case, dual compliance was possible. But if you had gone ahead to give notice to the defaulter, you would be frustrating the purpose of the federal law, which is that, once there's a default, secured creditor, go in and get your money. Does that make sense? Do you see frustration of federal purpose in there? Even though the possibility of dual compliance was possible. But if you give notice, you're frustrating the purpose of the federal legislation, which is to expedite liquidation of, securitized transactions that have been defaulted upon. Does that make sense to you guys? Right? So that's frustration of federal purposes. Sometimes it's very subtle. And so, honestly, in my opinion, even the NCA doesn't really question around that. If you have a federal paramouncy question, which you most likely will have in a judicial review on federal grounds question, the way judicial review on federal grounds question are presented is you have a long, stretch of facts. There's a legislation there, you probably have a bit of the sections of the legislation reproduced to you. You probably have a bit of insight on the pre-deliberative legislative evidence, right? Just to help you decide what the pith and substance. Remember pith and substance? To help you decide what the legislation is in fact about, right? And then you have A. Is it validly enacted by the province? B. If Cynthia and Daughters Railway Corporation transports people from Alberta to Toronto, to Ontario, to BC, to Manitoba, is all of a sudden uncomfortable about this legislation. Will that legislation be applicable to our? Do you see validity? Do you see applicability? And then C would be if the federal parliament passes a legislation that says XYZ, even though the legislation in your question has said ABC, which of these legislations will be operable? So typically it's presented more, within the context of NCA exam questions, more to emphasize impossibility of dual compliance. rather than frustration of federal purpose. But it's good that you also understand frustration of federal purpose, because my style of tutoring is never ever preempt the NCAs. No tutor is on the NCA examination board. We don't submit questions. We can study to say it is a trend, but and I personally believe that since 2009, when I wrote my exams, the NCAs have become so smart. The questions, you read the questions, you take 5 minutes of your time to give credit to whoever put the questions together to say, dude must be very smart. It's no longer that, federalism, chatter. They really touchlight a lot of easily neglected areas of the syllabus, right? So my style is don't preempt the NCAs, zoom in on it, but yes, still be guided in terms of what to spend the bulk of your time on. But never, get into the exam hall and anything you want to ask you is change. You must have at least read through it once, or at the very least know where it is in your material to be able to reference it, because again, it's an open book exam. Right, guys, any other questions? I mean, you all look so tired already. Thank you for your questions, Cynthia. And yeah, I'll give you my thank you that I give to people who turned on their cameras.
Thank you. Just one last question.
Sure.
Yeah, that's about the intensive class. I saw different times, so I just wanted to find out how long, like, is it that if you pick this time to this time, you only have class for that time, or does it continue to the other times? I'm trying to understand how the time works for the intensive classes.
So what happens typically, I mean, in recent times, what I do is we have a start date, and our start date is fixed in terms of date and time, right?
Okay.
And then at that meeting or that session, because in recent times, my last 2 or 3 days, a lot of people come in complaining. Initially, we had assumed that weekends will be comfortable for everybody, but a lot of people come in now. We get more complaints. I get more complaints to say, I work weekends, I work this, I work that. So at that first class, we take like 5 to 10 minutes to agree, on what day and what time we will be meeting going forward, trying to accommodate, everybody as much as we can. Does that make sense to you? So what is important is the first class, which will be communicated to you as soon as you you register, you pay for it. At that first class, everybody please try to make that first class, and then you can now register, your convenience or otherwise, and we can make a decision that hopefully, answers everybody's questions.
Okay.
I believe that the first class would be 2 weeks from now, 2 Sundays from now, I believe, right? Okay. I mean, so if there are no other questions or comments or issues, again, my name is Sheil Smith. I tutor constitutional law with the NCA Guides. Thank you for your time today. Hopefully it was beneficial. We offer paid intensive classes. It would be great, great, great. I get a vibe, all of you on my call today are super smart. It would be great to get your brains in one place and just throw you against one another and have you tear each other down. No, it's not that. Yes, it's this. Oh, is that. Right, absolutely. It was really nice to, this was really nice. I thoroughly enjoyed it. Hopefully you did as well. And it was nice to meet Amaka, Olabisi, Cynthia, and Sana. At least I met you guys and I can put a face to your names. Hopefully I see you at my paid classes. Thank you so much, guys. And all the best with your exams. All the best with your study. If you choose to self-study, and if you choose to study with me, see you in 2 weeks where I will give you a run for your money.
Thank you, Sheil.
Welcome. Thank you. Bye-bye.
Thank you.